Some expert reports lead to improvements in service, process, construction, or treatment. Your summary would include sentences that restate the original problem along with the key facts involved and your assessment of the primary causes and effects. You would end with your specific opinions, recommendations, or suggestions for corrections and changes to achieve the improvements in the future. If this report is intended to be corrective, explanatory, or just serve as guidance, then a well-written summary section may be enough for a reader. The rest of your report can serve as additional reading material to further clarify any questions that the reader may have. I've already spoken about exhibits to your report. These are usually attached like appendices to the end of your printed report. My first exhibit is always my CV, followed by a list of cases that I've worked on in the past. If I refer to other documents within my report that are not already part of the legal case, I include copies of those documents as exhibits to my report. They are then easily accessible to all readers of the report. Let me explain the phrase Bates stamp to you. Every page of printed evidence in a legal matter receives a unique identifying stamp, which includes letters and numbers typically. In court, then, experts and attorneys can refer to each page by this unique identification code, or Bates stamp. Every page of every document receives such a unique numbering stamp. When you refer to the contents of any such document in your report, you can refer to the Bates stamp number to guide a reader to particular pages in it. If a document to which you refer in your report does not already have Bates numbers from being previously admitted into evidence, just include the document as an exhibit to your report. Once submitted, each of the pages of your expert report, including the attached exhibits, will receive their own unique Bates stamp numbers. Let's talk a little bit about hedging and disclaimers. It sometimes happens that your expert report is requested before you have been able to do everything that you feel is necessary in the matter. If this is the case, you must say so in your report. If you think that further tests are necessary, but circumstances prevented you from doing them yet, you should explain this. If you think that more tests are necessary before you can finalize an opinion, then say that you plan to do the tests and will submit a supplementary report. Generally, you should discuss this with your client or attorney before you submit an expert report. Otherwise, this sets you up for either having to write a supplemental report later, when it might not be necessary, or having to explain why you did not perform the necessary tests. Sometimes deadlines for reports cause problems, but sometimes other circumstances get in the way. An important tactic, then, is to realize that you need to protect your reputation. You should not finalize opinions before the facts are in and you have taken all necessary steps. Experts sometimes include a disclaimer in their contract in an attempt to limit their responsibility in the case. Oftentimes, the client or attorney retains you and explicitly asks you to provide opinions on only a well-defined portion of the case. This limited involvement, by definition, will keep some facts from you. A disclaimer in your contract enables you to disavow any responsibility for elements of the case that you did not know about or that your work assignment did not include. At least, that's how I see it, and I've gotten advice to that effect, but recall, I'm not a lawyer. As an expert witness, you will have to make your own decision about whether you want to add a disclaimer as part of your own expert report.